Hello and welcome everybody to a brand new episode of r/ProRevenge. My name's Ryan, the official host here on Reddit Voice, and I look forward to bringing you guys today's top stories. Before I do though, I'd really appreciate it if you could hit that subscribe button, as well as make sure you got notifications turned on. That way you could stay up to date with all the latest and the greatest. Now that we got that knocked out of the way, let's jump into today's top stories. Our first story of the evening comes to us from Zakana, and it's called, I Got Fired. Employer's lawyer should have done their homework. I did. This happened to me about 20 years ago while in college. I'm being deliberately vague because reasons. Background, I got a job basically office sitting on weekends. I showed up at 8 a.m. and for every hour I checked things, handled the occasional phone call, and then left when the 4 p.m. person arrived. Most of the time I read, watched TV, or played games on my laptop. I probably worked there no more than 10 minutes of every hour unless something went wrong. It went on like this for years. The pay was decent, holidays were double pay, and I even had opportunities to cover weekday shifts when others were sick. One day, while I was covering the midday shift, my boss asks me to come into his office. He told me that the evening weekday position was going to become available that night. He offers me the position, which I accept, and I was told to punch out and return at 5 p.m. that night. The reason it went down like this should be obvious. Things went okay for a while. I showed up at 4 p.m., did the normal things, and then left at midnight when my relief arrived. It was a little more work, more call volumes, etc. Then, after 9 months, things started to go south. The daytime person developed a huge attitude problem and went from a nice person to a total Karen. She'd complain about everything I did. For example, one time a system jammed up a remote site and she called them. 5 hours later, I saw the jam was still there, so I called that site again to see if they were still working on it, or if something else was wrong because the woman on our end, who would be the one to help them, was leaving soon. They did have a problem, and so I hooked them up. My quote-unquote reward for making sure the problem got solved and not having to bother an upper-level employee at home on a Friday just after having left work was that I got yelled at Karen, and she had complained that I had apparently ignored her log entry about the issue. My defense was ignored. The boss had me highlight important things on the log to verify that I had read them. Things plodded on for a while with this new normal. I tiptoed around Karen when needed, thankful for the fact that I only had to deal with her for no more than 5 minutes. I did the stupid highlighting thing, and my log entries started getting more and more detailed, even referencing Karen's calls when I had to follow up on an issue that crossed shifts. The firing. The following summer, just after I crossed year mark, I went on vacation to visit some friends out of state. When I got back after about a week, my boss came down after everyone had left and had me describe how I did a certain task which involved certain updates. I explained to him how I did it and so forth. He then told me that I had not been doing it at all and that he was firing me. I had transposed the date code of the English file for the French file, which was the previous one. The newest one had already been applied anyways, so nothing was wrong. It was just a reason to get rid of me. I left the office. My state is an at-will employment state, which means that I can quit at any time for any reason, and my employer can terminate me at any time for any reason. The only exceptions were state and federal laws, such as race, religion, etc. I thought I was screwed, so I just started applying everywhere I could. During my job search, I accidentally happened to stumble upon a link about employment law. Out of curiosity, I read it and discovered that my employer had shot themselves in the foot. In the employee handbook, there was a job security clause. What this stated was that they would never lay us off and such if our jobs were eliminated. We could simply be retrained and sent to fill an opening elsewhere in the company. It sounds good, but it resulted in them cooking up reasons to fire people to get around it. But their fancy, high-priced lawyers had missed something. In my state's law, the one passed by the legislature, I was screwed because of at will. What they neglected was case law, the ones determined by courts. The site cited a case from the state's Supreme Court that had ruled a job security clause waived at will on the employer side. turning it into a just cause relationship. This means they had to have a real reason to fire me. The revenge. With that in hand, I sought out a lawyer. After my consultation with her, I set about collecting my evidence. My former boss did not realize that I knew more about his program than he did, seeing as I ran the same software on my own computer and laptop. I experimented. The date of the file, which they tried to use against me, is baked into the version too. I was able to demonstrate to my lawyer that if I applied the same update over and over, which my former employer stated would change the date every day, would in reality display the date of the file. I showed this by backdating my own copy a year using the update archive available from the vendor. Next, I showed her how the task used to be automated. A script would snag the file and process it every day on its own. A change on the vendor's site broke this script. It was an easy fix, but no one bothered to do it because the guy who had wrote it retired. The fix involved deleting 3 characters on one line in the script. The task was also marked as only being a weekday task. In my firing, I was told how important this update was and so forth. If it was so important, why was it not done on the weekends or on holidays? The vendor pushed out updates on those days too, as I showed my lawyer the one from Christmas morning. And why had the automation not been fixed? With all that in hand, she contacted them. After presenting them with the law they broke and all the evidence I had collected, they were forced to settle with me. So in the end, their fancy, high-priced lawyers did not do their homework. I did. Thank you to the wonderful librarians I've known in my life who taught me my information literacy skills. They paid dividends in this case. And now for the edit. Obviously, the terms of the settlement are confidential, and AFAIK still in effect. It was still a good portion of my salary, though. I did also get unemployment during this time as well. I never found out how the reaction went down, as the main corporate office that would have dealt with it was in another state, and I never had any contact with those people. I imagine a new handbook was issued before they cut my check, though, so I feel bad for those who remained. Karen's fate was sealed about a year later. I saw on a Facebook post by a former coworker mentioning that his job with them had ended, so I asked for details. The company experienced a huge loss in revenue. As a result, Karen lost her job as the site I had worked for was closed. Of about the 50 of us that worked in that office, only 10 or so were moved to another location. Thankfully, most of the ones I liked were old enough to retire. It didn't take a genius to realize my termination was simply a layoff disguised as a firing. That was a good one, but I got one more for you too. This one's by ECA Shepherd, and it's called Bank Screws Old Lady, Lawyer Screws Bank, Old Lady Gets Millions Back. Financial employers, advised by a pretty major bank, stole all the money of a wealthy old lady who was dying of Alzheimer's, and she didn't know anything until her lights were cut off. My brother was a pretty small-time lawyer and got the call to represent her. Every other big-time attorney in the area had either passed on the case or tried and failed to get anywhere. What, you're up against a legal team that makes a collective $10,000 an hour, it's not easy. Oh, for fuck's sake, maybe it wasn't. $10K an hour to Penny, give or take $1K, and you get the point. And since banks always have mandatory arbitration clauses worked into their contracts, she couldn't sue or even do discovery. OFFS, proper discovery. Then discovery as you and I know it, as it ought to be. Like, it was obvious what had happened, and the only people with access to the account were clearly implicated, but A, it was hard to prove without any access to bank records, and B, under arbitration, it wouldn't matter anyway. They could be criminally prosecuted, but the bank wouldn't have to pay back the money. Did I mention that the bank had, at this point, frozen the lady's access to her own accounts due to fraud, so she couldn't even get her own bank statements? FINRA did not really apply in this case for many reasons that I never understood properly, and then neither remember nor care about right now. Sorry about that, you guys. I am just falling over my words. Anyway, my bro became pretty obsessed with avenging this woman. By the time he got the case, she barely even knew what her own situation was most of the time. But her son just wanted to make the bank bend over, and my brother was all in. He managed to find an incredibly obscure technicality that nullified the arbitration clause and was able to force a major bank into the discovery process. That alone was a huge enough deal that the decision was written up for many legal newspapers. OFFS, journalists, figure it out, across the country. My technicality in TLDR form was that the bank failed to keep an original copy of the contract, so they couldn't prove that there was an arbitration clause. It's apparently normal for them to not keep the originals, but in this case they didn't even keep reliable copies, and neither person who signed the contracts could be deposed under oath to determine whether or not the clause existed. So the judge just threw out the clause. The obscure part was that the copies were almost exact duplicates of the original, but a few words had been changed and the pages were renumbered. He caught the differences and pointed out that they weren't true duplicates. It wasn't really a loophole in the law so much as a flaw in the bank's bookkeeping. After fighting and delaying discovery until the very last minute, the bank dumped 200 plus boxes of documents on my brother the Friday before the Monday discovery hearing. He had 72 hours to go through tens of thousands of pages of documents. For fuck's sake, is it really that unbelievable that a lawyer would try to keep a case moving along? Turns out he didn't need the continuance of so many of you experts claim he would have. This attitude explains a lot about the cases. He rented himself a hotel for the weekend so he'd have no disturbances, had a friend bring a dolly and hand truck of boxes to the hotel room, and got to work. In one of the boxes was an email between a bank VP and the bank's chief lawyer. I incorrectly described this as two VPs in my previous post. In this conversation, they're discussing how there would never be a discovery process, so there was no need to destroy documents, i.e. future evidence. Also saying that they weren't worried about the little old lady's lawsuit since the bank had frozen her accounts so she wouldn't be able to pay her lawyer and he was just a small-time country lawyer anyway. Their words. Who would surely quit once he wasn't being paid. It wasn't like he worked for some huge firm that could just pay his bills while he worked. They also discussed how the lady would likely die of Alzheimer's before the accounts would be unfrozen once the fraud was proven to be false. FFS! No, it's not necessarily addy-client privilege. Even I know that it's not a magic wand you can wave around to make everything disappear. It fell outside the parameters of privilege. Do you really think the bank would have settled if they felt otherwise? They had my brother all wrong, of course. He was working all day on paying cases and then staying up half the night working on this one, sometimes without getting paid anything for months. We did the math later, and he made about $275 an hour for his work over a span of 7+ years. Not $275, mind you, $2.75 USD. Anyway, these chuckleheads openly discussed several illegal acts in their emails to each other, and then failed to destroy the paperwork proving they had actually undertaken those acts, which legally they could have destroyed at the time, but they were so arrogant they thought they didn't have to. When my brother entered that into evidence Monday morning, they immediately motioned for a recess and offered to settle for an undisclosed sum. He also won his client $10 million in a separate part of the lawsuit. One agent recently finished serving a long sentence in the same federal prison as Bernie Madoff. He got prison time for tax fraud and some combo of bank fraud, forgery, perjury to the feds, and I think filing false documents. I can't remember which one of these he pleaded guilty to, but those were the original accusations. This is why he couldn't be deposed of in the arbitration clause part. He had already pleaded guilty to some of these charges and was indicted on others, so the judge deemed his word under oath to be unreliable. He also lost his home, the beach home he bought with the old lady's money, had his financial broker license revoked, and his wife left him. However, his kid did get a private college education paid for in cash with the lady's money, and he bought over $200,000 worth of wine that was never recovered. Sadly, the lady did in fact die before the case settled, so the money went to her son and to a large charitable trust that then elected my brother as the main trustee, so he gets to disperse the money he won in the settlement, and see a lot of people benefit from his work. The funny part of this revenge was that the apparent motive for the theft was not just that the agent wanted to be rich. He had accomplices, but he was the main mastermind. He specifically wanted to use the money to enhance his standing in the community. So actually, he donated a lot of the stolen money to charities so that he could be invited to huge galas, get philanthropic awards, etc. Now he's broke, unemployed, divorced, and disgraced, while my brother is going to galas and getting these same awards with the money this guy helped pay for with the sale of his house, cars, etc. Pretty sweet. ETA, I feel obliged to spread the anti-arbitration gospel of my brother. If it weren't for a fluke of technicality that led to the boilerplate arbitration clause being thrown out, there would have been no discovery and no justice for this lady. Under arbitration clauses, you're not allowed to sue a bank, brokerage, financial advisor, etc. And without a lawsuit, you can't do discovery. Financial agents cannot be forced to pay you back for money they steal, even if you can prove they stole it. At this case, discovery led to evidence of tax fraud on that part of one of the agents who stole the money and didn't report the income, and the feds gained a lot more access to the records. In conclusion, arbitration benefits the corporation 98% of the time at the consumer's expense. Opt out whenever possible. Well, there you have it, folks. The end of the epics! That was probably pretty loud, I'm sorry about that. If you like these stories, be sure to leave a like on the video, as well as make sure you're subscribed with notifications turned on so you could stay up to date with all future videos. As always, my name's Ryan, the official host here on Reddit Voice, and I look forward to seeing you guys in tomorrow's video.